Who are you? And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and we are here every Monday at 10 a.m. Pacific time to talk about all those things related to estate planning and trust and probate administration, whether it's for your own needs or for those of you who, like me, are professionals who help people with these situations. So today I'm going to be talking about something that's California centric, and other states I think have similar processes. I would say that so often, as goes California, it seems like a lot of the country follows, behind. Unlike many of the things that come out of California, at least in theory, this particular California innovation, for want of a better word, it is really meant to help people, especially lower income people and people without a lot of assets. It's intended to help them out. And so the topic is what's called a small estate probate. So we've talked many times about avoiding probate using things like living wills and all that sort of thing, beneficiary on death designations, etc. So despite that, and despite all the tools that are available to us, many people die either intestate and they do no estate planning, or for various reasons, there's a defect in their will or something like that. And so in essence, when they die, they leave behind property with no clear direction on what's supposed to be done with it. So especially if there's not a lot of money, or I shouldn't say money, let's use the word value in their estate, to have to go through a probate can be expensive, and it could significantly defray the value of the estate to the detriment of the heirs. And so California has created a number of rules in the probate code. I'll give you those specific sections at the end. But for the administration of a small estate. Okay, and the idea is that a small estate can avoid a formal probate procedure, and therefore save quite a bit of money. And again, toward the end, I'll compare the fees for the two, or the estimated fees for the two. Let's start out now by defining what is a small estate. So in California, if an estate consists of only personal property, that means there's no real estate. Could be bank accounts, stocks, vehicles. It could even be artwork. Anything that's personal property is property that's generally movable. Okay, all intangible property as well, it would be considered personal property in this context. So if they had crypto assets, those kinds of things, those are, it would probably be better say non-real property assets, but personal property assets. And they're valued at $184,500 or less. Then, rather than going through the regular probate process, the heirs can use an affidavit to claim the assets. Okay, so first of all, let's just take a little bit of a step back here and say, well, how do we know who the heirs are? Well, there may be a will, okay, and if there is a will, so the will, hopefully it's properly drawn up, and the will is clear on who the heirs are. So in that case, the heirs know who they are. Okay. In the absence of a will, so then what are known as the laws of descent and distribution will have to be followed. So in California, if someone is still legally married, okay, so then their spouse gets a certain percentage of it. If they have any children, their children may be heirs under the will. Okay, so I mean, maybe heirs of the estate. If the person dies intestate, it is more difficult to determine who an heir is. And at that point, even though the small estate procedure is designed to help people avoid having to use an attorney, at that point, you may be well advised to get some legal advice so it doesn't turn into a big mess, because people who were heirs, legal heirs, were left out. And so now there's fights because somebody got all the property and they weren't entitled to all of it, and now you're in a big lawsuit. Okay, but so let's just take a situation where there is a will and the will is drawn up correctly, and so it's clear who is an heir. And in the case of someone who might be an heir under the law, they've been specifically disinherited. Okay, so then the heirs can claim the assets into the estate using the following procedure. So first of all, they have to wait, excuse me, 40 days after the decedent's death. Okay, so they're going to have to a little over a month. Okay, let the dust settle. Next, they prepare an affidavit. It's called an affidavit for collection of personal property under probate code section 13,100. Okay, and by the way, I'll put some links to some of these in the show notes so that you can look them up if you want to. Now, by the way, I should have said this at the beginning. As anyone who's watched the show before knows, I am not a lawyer. Okay, I am a professional fiduciary, so I am not giving you legal advice here. I'm informing you about what the law says, but how you apply it to your specific situation, that's for you to determine. Or if you're not sure, if you're not experienced in these matters, for sure get proper legal advice. Okay, you may be reluctant to hire a lawyer; they can be expensive. But as the old saying goes, an ounce of prevention is worth a pound of cure. And I can tell you, in my practice, whenever that is violated, people end up in a huge mess. It often takes years for a probate to be settled, much to the detriment of the heirs. Okay, so so under, again, probate code 13,100, an affidavit for collection of personal property is prepared. Okay, and then supporting documents are attached to the affidavit. That includes a certified copy of the death certificate, which you can order from the county recorder in the county in which the person died, as well as proof of the asset's value. So if it's a bank account, a bank statement; if it's a brokerage account, a brokerage statement; if it's a vehicle, go with a vehicle, I think you can just go to the DMV. I don't even think you need. I don't think you even need to. Well, if you're a spouse, you don't need to do this. But you can just go online and go to like kellybluebook.com or something like that, and bring a copy of the registration of the vehicle, along with a printout about what the vehicle is worth. And that's I think that's probably all you need to do. Okay, and you go and you present it to the holder of the property. It could be the bank, it could be a brokerage company like they've all merged so much these days. UBS, or somebody like that, Fidelity. Okay, the DMV. Okay, and they should release the property to the heir. Now, they may not do it right there on the spot. Okay, so if it's, for example, Fidelity, okay, they have a department that handles transfers of property of decedents. Okay, and there's forms that need to be filled out. They need to be notarized, generally speaking, and there's a process that has to be gone through. But you should be able to accomplish that process without having to open a formal probate. Okay, so why am I bringing this up? Why am I bringing this topic of small estates up now? Well, it just so happens that a law was passed here in California. I believe it was last year, Assembly Bill 2016, and it amended the small estate probate rules so that now, if an estate includes real property, for example, a house, worth up to $750,000, beginning on April 1st of this year, the heirs can also use a simplified court process that avoids probate. Okay, so let's just take a simple example that the decedent had a house. The house is worth $500,000. Okay, so that fits within the $750,000 limit. So the heir or heirs, they file a petition to determine succession to real property under probate code 13,150. Okay, it's filed with the court. So it's not super easy to file a court petition, but the people at the court, if you are a lay person, they will help you. Okay, they may be a little gruff. Okay, but sort of deal with it. Almost all of this stuff can be done online nowadays. Here in LA County, for example, the online portal for LA Superior Court is excellent. It's the best one I've dealt with, and I've dealt with them in several court jurisdictions here in California. Okay, if you're not in LA Superior Court, so if you're in Riverside Superior Court or some other jurisdiction, you might have to go down to the court itself. Now, outside of a big jurisdiction like LA or Orange County or San Diego, it's easier to deal with the court. The court people are much friendlier. They're much more helpful. Okay, but you'll prepare this petition to determine succession to real property. Okay, and then you have to give notice to heirs and interested parties. Okay, so and if let's say there's 3 heirs to the decedent, okay, and one of the heirs decides to file this petition, so they're going to have to give notice of it to the other 2 heirs. Now, let's say also there's a loan on the house. Okay, so the lender is an interested party, and notice would probably have to go to the lender as well. Now, by the way, this is a new procedure. Okay, it hasn't even started yet. It doesn't start until April 1st. So how exactly this is all going to play out, there's lots of discussion about it going on right now, but it's not 100% clear how this is going to handle. So if you decide, if God forbid somebody passes away next month in April, and you decide this is the proper procedure to use, or you consult with a lawyer and the lawyer advises you to use this procedure, just beware that it's new for the court. Okay, and so judges and clerks and people in the in the filing department, the clerks there, not the court clerks, but the file clerks, they all have to figure out how this is going to work. Okay, because they haven't done it before. Okay, now then there's going to be a court hearing. Okay, and again, I think all the courts in California allow you to appear remotely. I know in LA Superior Court, they use Microsoft Teams. In Riverside Superior Court, they have some sort of proprietary system, I think, or maybe it's Zoom. Each court has, its own system for doing this. Now, I can imagine in some, far northern California courts, where they're very low population counties, maybe they don't have virtual appearances yet, and so you may have to show up at court. But again, in a small county like that, it's much easier to do, and you just show up at the courthouse, and the people there are going to be able to help you. Okay. Now, if there's no disputes, the judge may approve the transfer of the property. Okay, so then what'll happen is if the judge approves the transfer of the property, usually later that day or the following day, the judge will issue an order ordering the transfer of the property. Okay, and then the heir files the court order with the county recorder's office, and that transfers title to the property. Now, by the way, if there's a loan on the property, okay, there's a good chance the court is not going to order transfer of title because that would take away the lender's security. So some kind of arrangement is going to have to be made either to pay that loan off or for the loan to be assumed by the new owners. So if I were handling something like this, and I wouldn't be doing this professionally, but say for myself. So I would talk to the lender first before going through this whole process, because if the lender's going to object, then the small estate petition for transfer of real property, the judge may not approve it. And so now you're back to, filing a probate, and you might as well have done that from the beginning. Okay. So now, I'm going to go through a few more things about small estate. Well, actually, let me do this here. So if you cannot use the small estate petition process, then you're going to have to go through a full probate. That means submitting the will to probate, and for the appointment of the executor named in the will or for some other personal representative. That's the first step. And then letters of administration have to be issued by the court. And that's when the probate process can begin. And that process alone can easily take 2 to 3 months. That's if there's no objection to the person who's requesting being appointed as the personal representative. Okay, so you can see right away that if you have to go through a full probate procedure, it's going to take a lot more time. Okay, I'm going to talk about the cost a little bit later on. Okay, so if you can use the small probate process, that is generally speaking going to be beneficial. Okay, but you won't always be able to use it, I suspect. Now, so what are the benefits of the small estate procedures? Well, one is there's no formal probate, and a formal probate, generally speaking, will take about a year. Could take more, could take 2 years. Okay, it depends if any disputes arise. That can lengthen out the time. It depends on the size of the estate. Now, in a small estate like this, where you've got less than $200,000 of personal property and a house worth $750,000 or less, you're talking about under $1 million. Okay, generally speaking, if there's no disputes, you can probably get through the probate of that estate in about a year, maybe a year and a half. Okay, but that's considerably longer than the probably 2 or 3 months that the small estate petition and affidavit process would take you. Okay, so it's 4 to 6 times longer to go through a full probate. Now, since I raised the issue of a lender on the house, okay, I want to talk a little bit about the priority of debts in a small estate. So merely because you can gain, meaning the heirs, or I should say the heirs to the estate, can gain ownership of personal property through the affidavit process and real estate through the petition process, that does not mean that the debts of the decedent disappear. They are not canceled. Okay, they need to be dealt with. Okay, and if you don't deal with them, it could come up and bite you, so to speak. Okay, so first of all, let me just give you the priority of debts. Now, the reality is, although I'm giving you the priority of debts in the context of a small estate, this is the same priority of debts for any estate. Okay, whether you're going through a full probate, whether you're administrating a trust, doesn't matter. Okay, so Highest priority debt is funeral expenses, right? That's to make sure the decedent gets properly buried or cremated, whatever is going to happen, that they have a proper funeral. The second is estate administration costs. Okay? Otherwise, people facilitating the administration of the estate may not want to get involved if it's not clear that they're ever going to get paid. Okay. And it can be the case that debts besides funeral expenses and administrative costs exceed the value of the property and the estate. And if that's the case, okay, then if funeral expenses and administrative costs were not given priority, the property could well sit there and the estate would never be settled. Okay, so number one, funeral expenses. Number two, costs of estate administration. Number three, secured debts. Okay, so a loan on real property or a car loan. These are loans that are secured by a property. Typically, the loan was used to buy the property, although that's not always the case. So when, like, if you bought a house and you had a loan, you got a loan to buy the house, that's what's called a purchase money loan. But let's say 5 years later, interest rates dropped and you refinanced the property. That refinanced loan is not a purchase money loan, okay? Nonetheless, it is a secured debt. Okay, so it has number three priority. Number four priority is taxes, federal and state taxes. Now, in a small estate, it's not going to be estate taxes. Those are exempt. Okay, and it's unlikely that even if the estate tax exemption drops to its pre-2017 level, it's very unlikely that it'll drop to the point where a small estate, as defined in California, would be taxable. But someone may owe income taxes. Okay, they may owe property taxes, or they may owe some franchise taxes. Okay, so all of these have fourth priority in terms of debts. Number five, medical expenses related to the last illness. Okay, maybe the person was in a hospital or hospice care, something like that, ambulance, whatever it is, those have number five priority. Number six are unsecured debts, things like credit cards and unsecured personal loans. Okay, there's no property securing those debts. They write a credit card. You get a credit card based on your credit score these days, essentially. Okay, so those are the six types of debts in priority. Okay, so when the small estate affidavit process is used for personal property, okay, they inherit the obligation to pay the debts from those assets. Okay, so let's say there's a brokerage account with $100,000 of securities in it, but some of them were bought on margin. And so there's a margin loan, let's just say $25,000, okay? So when the heirs, through the affidavit process, inherit that portfolio of securities, they inherit it subject to the margin loan, okay? And depending on the terms of the account, it may be that, upon transfer, the margin loan has to be paid off. Okay, so that could vary from brokerage to brokerage. Okay, so the affidavit does not eliminate the debts. Okay, so when the heirs may have to settle that debt and use inherited funds to do that. Okay, so again, before you if you have information, let's say about a brokerage account, check and see, does it look like there's a margin loan on it or something like that? And if so, just know that you're going to have to deal with that as part of the affidavit process. Okay. Next, and by the way, creditors can make claims against the heirs if their debts remain unpaid. So let's say the heirs inherit $150,000 in bank accounts and stocks and bonds and such. Okay, so it fits under the affidavit process. But let's say that the funeral home did not get paid, or let's say that there are some unpaid taxes. Merely because now the heirs are the owner of the property, that doesn't mean that they escape paying those debts. The creditors could look to the heirs to pay the unpaid debts up to the amount of what they inherited. Okay, now the court, except I've never seen a case where this has happened, but in general, the court is not going to hold the heirs responsible for debts in excess of the value of the estate. But the courts do have the authority and likely will hold the heirs liable for debts up to the value of what they inherited, because those debts, the creditors have the right to get paid before the beneficiaries, the heirs, get their share. Okay, now for the small estate petition process for real property, okay, again, as I mentioned earlier, the court may require that the debt secured by the real property or other debt claims that are filed be paid prior to ordering the transfer of title. Okay, so, and the court would have the authority to order the property sold if the debts exceed available liquid assets. Okay, so let's say you've got a situation where there's a $500,000 house and a $100,000 brokerage, bank account and brokerage accounts. Okay, so hang on one second here. I always forget to close my email and you hear that dinging. Okay, so there's $100,000 in bank account and stocks and such, and there's a $500,000 house. And let's say outstanding debts are $200,000, meaning that it's twice as much as the liquid assets. In a case like that, okay, the court may order, even through the small estate petition process, the court has the authority to order the sale of the property in order for the debts to get paid. And then whatever is left over from the proceeds of sale would then go to the heirs. Okay, now the time frame for creditors to make claims in a small estate probate are different than a full probate. They're actually, creditors have a longer period of time, and that's only reasonable since there's no process by which they have to be notified in the small estate procedure. Okay, so creditors typically have 1 year from the decedent's death to file a claim, even if no formal probate is open. Okay, so if unlike the formal probate proceeding, where creditors have a very strict time frame that I'm going to tell you about in a minute, creditors may still pursue heirs if they inherit assets but fail to pay debts. Okay, so even if they and again, it's not clear how this is going to work, but the way I read it is, and your lawyer may read it differently, that let's say a creditor didn't find out for 18 months that its debtor had died, and in the meantime, the heirs have taken ownership of the property. I read this as the creditor may have the ability to come after the heirs to pay the unpaid debt, even though it's been longer than a year. But again, probably only to the extent of the amount of money that the heirs inherited. Okay, now let's look at the formal probate process first, and then I'm going to talk about a couple of exceptions. So in a formal probate process, Creditors generally have 4 months from the date the court appoints a personal representative, that is an executor or an administrator, to file a creditor's claim against the estate. Okay, so in a formal probate case, the personal representative must notify known creditors of the decedent's death. And then creditors have the later of 4 months from issuance of the letters of administration or 60 days after they receive notice from the personal representative. So you can see that the timeframes are much shorter. And if the creditor waits until after those deadlines pass, the creditor may not be able to pursue a claim against the estate. Okay, so you can see that one of the things that about a small estate probate is it does give creditors a lot more time to see to it that their debts get paid. Okay, now we're talking about sort of commercial creditors, right? Because there are exceptions. You want to guess what one of them is? Of course, the government. So government claims, for example, Medi-Cal recovery. So they have their own deadlines. They often are longer than the usual creditor period. Okay, and so don't think that because Medi-Cal didn't come after you, or Medicare didn't come after. I'm sorry. Medi-Cal, Medicare didn't come after you for your deceased relatives, reimbursement claim, and now you have ownership of the assets that you're not going to have to pay them. That's not how the government works. The government has its own set of rules, and it's going to get its money. Okay, now, if the creditor misses the deadline, they can petition the court for an exception. Now, I've never seen one granted, but that doesn't mean that they aren't granted. However, I would imagine the burden of proof will be on the creditor to show good cause as to why they missed the deadline. Okay, and it wasn't just oversight or negligence on their part. Okay, so what happens if there are more debts than assets? Okay, so in any estate where there's more debts than assets, the estate is considered insolvent, whether it's a small estate or not. Okay, creditors are paid based on the priority that I explained before, and so lower priority debts may go unpaid. So if funeral expenses, costs of administration, and secured debts altogether use up all of the value of the assets of the estates, the unsecured creditors are probably not going to get paid, and outstanding taxes may not get paid either. Okay, now, as I mentioned before, heirs generally are not personally liable for debts beyond the assets that they inherit. Okay, now the exceptions to this would be if an heir co-signed for a debt, and so they're partly liable anyway, or for example, a community property liability where one spouse is inheriting the other spouse's community property interest. So in that case, they might be still held liable for the debt, even though there were not sufficient assets in the decedent's estate. Okay, so this starts to get very complicated. Okay, and so again, this is where you would be well advised to consult with an attorney who specializes in estate, trust, and probate matters. Okay, and get that ounce of prevention that is better than the pound of cure, so to speak. Okay, now, so those are the debt procedures. Now, I'm going to talk about the costs of a small probate in California. Okay, so first of all, there's going to be court filing fees. So to file a small estate petition for real property is going to cost maybe somewhere between $400 and $700. It depends on the county. There are different filing fees and such. You may have to have if there's not online filing, you may have to pay an attorney service to take it down to the court and file it, or you may have to go down to the court and file it. Okay. The affidavit for collection of personal property, there is no court fee for doing that because it happens outside of the court. Okay, so there's no cost there. Okay, legal and professional fees may be zero on a small estate process because it's simpler, and it's designed for people to be able to do it without the help of an attorney. However, if legal help is needed, okay, attorneys who practice in this area generally are charging somewhere, probably in smaller counties, around $250 or more. In larger counties like Los Angeles, I think you'd be hard pressed to find one who charges less than $400 or $500 an hour. And if it's very complex, they're likely to charge even more. Now, there are some lawyers who will handle certain things on a flat fee basis. Okay. And if you've got a small estate, maybe you can get an attorney to agree to help you for a flat fee, $1,000, $1,500. That may still be considerably less than the attorney charging on an hourly basis. Okay. And then there'll be a tax preparation fee. So the decedent's final tax return will have to be filed. And a 706 may be a 706, which is an estate tax return. Even though there's no estate taxes to pay, a 706 may need to be filed. And if so, you're going to need an accountant who knows how to handle these types of tax returns. Okay. Not every accountant knows how to file the tax return for a deceased individual or how to file a 706. And their fees, like with lawyers, can vary. Sometimes you can get them to agree to a flat fee, especially if it's simple. Other times it's going to be an hourly fee. Okay. So talk with them, talk with, your accountant if you have one, or if you don't have one who knows how to do these, talk with a couple of them before you make a decision, and talk upfront. What do you estimate the fees will be? Okay. All right. Next, if a small estate probate involves real estate, okay, and you're going to use the small estate petition, nonetheless, the court may still require that a probate referee appraise the property. Now, they call it an appraisal. Most appraisers would agree it is not really an appraisal in the context of how that term is used in ordinary business. But they do evaluation, I think would be a more accurate term. Okay. The fee for that valuation is generally 1/10 of 1%. So if you have a $500,000 home, the probate referee is going to charge $500 to do the valuation. Okay. So you may have to do that as well. Okay. Certified copies and recording fees. So a death certificate, it can cost, the filing of it there, that'll typically be done by the funeral home or perhaps the hospital. Okay. They're going to include that in their bill. If you need copies, though, the county recorder charges for each copy. Now, those fees are going to vary by county. They may be $10 a copy, $20, $25, whatever it is. You're probably going to need multiple copies. Okay. So, and the thing is, it can take, I know here in Los Angeles County, it can take sometimes 6 weeks to get a copy of the death certificate. So you're not going to want to wait each time 3 to 6 weeks or more, even if for some reason the system goes down or something, to get copies. So you probably want to have a number of copies on hand, okay, so that if you need them to use with affidavits or to submit to the court, you have them available. And those are certified copies, right? To take an original death certificate and copy it in a copy machine, a lot of institutions will not take that because it's not a certified copy, okay? And so they're going to ask for that certified copy. Some may view it, accept it, and return the copy to you. So, for example, canceling a passport, the Passport Bureau, you send it to you send the paperwork to them along with a certified copy or original of the death certificate, and you can request that they return it to you, and they will. Okay, I know because I've been through the process. All right, and then the counter recorder's fees. For example, if you're using the small estate petition process for transfer of real estate, you're going to have to record the court order. And again, that varies county by county, but it can cost $50 to $100, something like that. Okay. Creditor notification and debt payments. So there are no formal creditor claims process in small estate procedure. And so, any cost of notifying creditors is going to be negligible, maybe some postage or maybe some emails, something like that. So negligible. Okay. Miscellaneous costs. You may have notary fees, and depending on whether you go to the notary or they come to you, could be, $25 a signature, $50. It's just going to depend. Okay. Now, bonds. Rarely are bonds needed in a small estate probate case. But if you need a bond, then there will be a bond fee as well. And in my experience, the bond fees too are generally about 1/10 of the value of the property. So again, on a $500,000 house, the bond fee would be maybe about $500 if the court ordered a bond. Okay, so total estimated cost for a small probate without real estate in it, maybe up to $1,000. With real estate, could be $1,000 to maybe as much as $5,000, depending on depending on attorney's fees and probate referee fees. Now, let's contrast that with the fees that you would pay for a formal probate. So in addition to all the fees that I've just mentioned, the personal representative of the estate, as a matter of statute, gets what are called statutory fees, okay? And those fees are on a sliding scale from 4% to 0.5%. So on an estate valued at $1 million, those fees are going to be $23,000. On an estate valued at $200,000, they're going to be $7,000. By the way, the statutory fees for an attorney to represent the personal representative are the same as the fees to the personal representative. So on a $200,000 estate, which is only slightly above the personal property limit, okay, so maybe it would be the personal property limit might be the fees. If an estate were within the personal property limit of $184,500, the personal representative fees might be $6,000, and then another $6,000 for the lawyer representing the personal representative. That's $12,000 in addition to the $1,000 of other fees. So you can see it's much, much higher. Once real estate gets involved, let's take an estate where there's real estate of $700,000 and there's personal property of, let's say, $150,000. You've got $850,000. Okay, so your fees on that are going to be around $20,000 for the personal representative and $20,000 for the personal representative's lawyer. In other words, around $40,000 again, plus all the recording fees and the probate referee and all that kind of stuff. That could be another $5,000. So you can see that the formal probate procedure is much higher, much higher, but orders of magnitude higher. So that's why California law sets up this small estate procedure. It allows small estates to be settled much more cost efficiently. By the way, this also shows you the wisdom of if you're using the small estate procedures of getting a little bit of legal advice and avoiding a dispute that pulls it into a formal probate. Okay, so even if you end up paying, let's say, $4,000 in attorney's fees in addition to $5,000 in other costs, so now your costs of administration are $9,000. That's still significantly less than the $21,000 to $45,000 that a formal probate would cost. Okay, so that's what's at stake here. Okay, now okay, so I'm going back to this the law that was passed last year, Assembly Bill 2016, that said starting April 1st, there are going to be changes to the small estate procedures. The law permits this transfer of primary residences up to $750,000. Plus the personal property limit of $184,500 stays in place. So you've got almost $1 million that will avoid probate. Now, now you might be saying to yourself, oh, pardon me. You might be saying to yourself, well, property values, real estate property values in California are so high, big deal. So houses worth $750,000 or up to $750,000 are exempted. That doesn't mean anything. Well, the reality is that as of January 31st of 2025, the average home value in California was $773,000 and change, okay? Which means that roughly half of houses are worth less than that. I should say the median home value. So, while not literally 50% of homes fall within the exemption or the small estate limit, maybe somewhere around 40%, 45% do. That's a lot. That's a lot of people now who could potentially avoid probate who could not prior to this law going into effect on April 1st. Okay, so it is a big benefit. See, we sometimes we can maybe do something right here in California. Okay, now consideration for estate planning. Okay, given the increased threshold, it's a good idea to have your estate plan reassessed, okay, to determine, is there a way to align it with the new provisions and maybe without having to go through the cost of forming a trust, set up your estate so it can avoid probate, okay? Maybe you transfer some assets before you die to decrease the value of your estate or something like that. These are all things for you to talk to an estate attorney, an estate planning attorney about, and see if this new rule changes anything about how you're going to handle your estate. Okay, so while generally I recommend having your estate plan reviewed anytime there's a major change in your circumstances in your family life, but at least every few years, when there's a change in the law like this, this may also be a trigger that you should have your estate plan reviewed. Now, if you own a house that's worth over $750,000, and it's very unlikely that it's going to decrease in value, so then there doesn't appear to be any benefit to necessarily having your estate plan reviewed simply because of AB 2016, because you're not going to be able to take advantage of it. Okay, so I'm going to put these in the show notes. But the bill amended probate code sections 13,100, 13,101, 13,150, 13,151, 152, and 154 of the probate code. And it also repealed probate code section 13,158. Okay, so if you want to read the specific language of the probate code affected by this new law, I'll put a link in the show notes to that part of the probate code, and you can do so. Okay. Reading the law, though, again, is not necessarily grounds to not get proper legal advice. Okay, there is no substitute for proper legal advice in these matters. And I'll say it now, I think for the third or fourth time, an ounce of prevention is definitely worth a pound of cure when the fees for having to go through a formal probate process are so much higher than they are going through the small estate process. Okay, well, so a lot of information. Did my best to make it as clear as possible. And hopefully it was. If it wasn't, maybe watch through the show again, or talk to some people who like me are familiar with probate process and get their thoughts on it. Okay, it's always a good thing to get more than one party's opinion. Okay, I make no claims to immutability or anything like that, or non-immutability, whatever the word would be. Okay, so let me take this opportunity to thank you very much for joining me today. It's the show wouldn't be the show without you watching, so I deeply appreciate that. If you have any questions, comments, thoughts, my links to my social media will be in the show notes as well. Feel free to post them. If it's of a personal nature, you can feel free to send me an email. My email address will be in the show notes as well. Okay, now with the caveat, as always, that if it's within my area of professional expertise, I will do my best to respond. And if it's not in my area of professional expertise, if it's a legal question or an accounting question, something like that, then I will respond as such. And if you want me to refer you to a lawyer or an accountant, I will be happy to do so. Okay, so before signing off, tomorrow on Tuesday at 10 a.m. is my show, Business Lessons from the Military. And my guest is Derek Keller, Marine Corps veteran and business advisor, and he's going to talk about how to propel meteoric growth. And then on Wednesday at 10 a.m. Pacific time, I have really a treat. Mike Povsky and his colleagues at Underground Studios are all going to be on the show. I think it's going to be a bit of a raucous time. These are really astute young businessmen. I met them now probably about a year ago, and just am so impressed by their drive, their acumen, the business that they're building. And I think you will really be inspired by Mike and his colleagues. So join me on Wednesday at 10 a.m. Pacific time. And then on Thursday at 5 p.m. Pacific time is my every other week show, Jiggers' Place. We're going to have a cocktail and talk about how can we renew societal institutions. I'm sure you know that trust in our societal institutions is at, I think, an absolutely all-time low. I want to share some thoughts on what we might do about this. It's in my opinion not a good thing that we have so little trust in institutions that are meant to bring cohesion to our society. So I hope you'll join me for that. And then a week from today, I'll be back with the next episode of Trust in the States Weekly. My guest is going to be Brian Whitland, and so I hope you will join me and Brian and listen to our discussion. So once again, thank you so much for joining me. Deeply appreciate it. Hopefully I'll see you again later this week. And signing off as I always do. Marie, darling, you are my belle. Courage at all times, my friends.